representative of the claimant, would you like to take me through the case memorandum, as well as the documents you wish to rely on during today's meeting?
Yes. So the court should have a copy of a CMC bundle, which was uploaded last week. Now, there have been some further evolution to some of those documents. But if I take you to the index of the CMC bundle, we have claim form, the particulars of claim, a summary of defence. Now, we didn't include the defendant's defence, but I don't think that should be an issue today. I don't think we will need to turn to it. And also there's a copy of our reply. Now, in section B, we've got the agreed case memorandum. There's also a draft order which the parties have been discussing. And I believe there's an updated version that has very little in dispute. Now, does the court have a copy of the latest version? Is it something that we can assist the court by providing during this hearing?
So the latest version is the one that was sent to the court on which day, or was it uploaded? Just to make sure I have the same one. Mr. Nguyen?
Yes.
Yes, just to double check, this is not the updated case management conference order is not the order that was submitted with the e-bundle?
That's my understanding. I'm just checking.
Okay.
That's correct, yes. The version submitted with the e-bundle has, I've got it in front of me, paragraph 1 is all in blue amended text. The latest version, it also has amended text, but the first paragraph is crossed out, it's in red, and it then has some blue text within it. And I guess the essence of the changes is that the claimant has provided the defendants with its proposed amended particulars of claim. The defendant's position is, as I understand it, subject to an appropriate costs order. They consent to us filing and serving those amended particulars of claim. Is there a means by which it's possible to provide the court with this latest version?
If you can email it to the registry right now, Mr. Nguyen, I would receive it into my inbox.
Thank you. I will entrust that to my instructing solicitor. As I hear that.
That's perfect.
Thank you. So whilst that's taking place, going back to the index of the case management bundle, that's the draft order which is under negotiation, which I believe is largely agreed, but let's discuss that when we all have a copy in front of us. There's the claimant's CMC information sheet, and the defendants have also submitted one. And then there's a list of issues, which is, it states is under negotiation. Now, my understanding is that the version in the bundle is essentially agreed. There, perhaps if I could take the court to the list of issues, it's the last 6 or so pages of the bundle. It starts at page B18, 18.
Mm-hmm.
No doubt my learned friend will correct me if I've misunderstood, but this version, as you can see, has tracked changes, but it also has in the column on the right comments. Now, the version which, as I understand it, has been agreed is this version without the comments. And the reason that it is the version without the comments is that the comments refer to the claimant intending to provide the defendants with the draft amended particulars of claim, and that this agreed list of issues, as it were, is subject to that process. Now, that process has been carried out. We have submitted the draft amended particulars of claim, and as I understand it, subject to any costs order, the defendants accept that those can be filed and served. So it may be useful for the court if it is confirmed or discussed between us that this is the list of issues that we've all agreed.
If it is this, I can confirm 2 things. First of all, the amended particulars of claim that have been provided to the defendants in draft, they are agreed, as Mr. Wynne says, now that the claimant has agreed the costs order that was being discussed between the parties. And on that basis, secondly, the list of issues is agreed in the form that the court has it.
So just to confirm, the list of issues currently, the one I have before me, in section B of the e-bundle, this has been amended.
I very much hope that the version that the court has at section B of the e-bundle, as Mr. Wynne says, has some blue text with track changes and some comment boxes on the side.
Yes.
And with the exception of the comment boxes that we can effectively put a line through now, this is now in agreed form. And it may be that what's most helpful is if the parties send a clean version of that to the registry after this hearing.
So that would be helpful.
That's my understanding.
Thank you, Mr. Wynne. So all seems in order with the list of issues. I do want to see the agreed case management order, just because I have a few comments to make on the form of the order. And while we're waiting for that to come in, I just would like to discuss or confirm the parties' understanding on the, or the parties' agreement as to the trial length. So I believe the position, based on the note that was submitted by the defendant today, is for the trial to be listed for 10 days. Is that correct?
Yes, that's certainly my best estimate at this point. There's a significant number of witnesses and obviously quite a lot of factual material that needs to be assessed by the court.
Well, I seem to find the length a bit disproportionate. I don't know if there's any way we can take sort of I don't really know what would be the best approach, but I think is there any way we can reduce the amount of witnesses? Is there a timetable that you can sort of provide us with just to see where we can
Reduce
cut down on? Yeah.
May I just ask, for Mr. Wynne, the claimant's indicated that she intends to call 2 to 3 witnesses, but she hasn't identified those witnesses yet. Can Mr. Wynne confirm who they are likely to be?
I don't have their identity at this moment, I'm afraid.
I believe that the defendants might have a greater amount of witnesses. I believe the defendants are calling about 7 witnesses, if I'm not mistaken.
That's exactly correct.
And is that the standard, Ms. Rogers? Is that the confirmed understanding, or is this subject to change once you or your client has had sight of the witnesses that the claimant intends to call?
You're exactly right to raise it. At the moment, that is the confirmed position, but subject only to understanding who the claimant is likely to call. If it assists, and certainly on the defendant's side, 10 days seemed to us a listing that was certain to accommodate the case within the allotted time. I have no doubt that, as always, if the court's indication is that the parties should complete the case more quickly, certainly that can be done. And if the court felt, for example, that a period of 8 days perhaps was more proportionate, for my part, I'm confident that the case could be completed in that time.
I also think that as the case progresses, it may be possible to have a clearer view of what issues can be dealt with more quickly and what need to be dealt with at greater length. So it may well be that as we get nearer to the final hearing, it's possible to be more accurate and to come up with a slightly shorter assessment. That would certainly be my hope.
All right. My only concern is, in order for the court to accommodate such a listing, I believe looking at the timetable set and the draft that I have, we're looking at a possible listing during, I would say June or July.
I'm grateful. And may I just confirm from the outset, July causes difficulties for my witnesses and my client. So, as I'm afraid is August. So we'd be very keen for a hearing at the end of June, if that's feasible.
I think it would be very difficult for the court to accommodate a 10-day listing. In June or at any other time, actually. But we can leave this aside just so we can discuss the possibility of mediation proceedings. I think it was the claimant's case management information sheet that set out that the parties would be amenable to sitting down with a judge of the DIFC courts to go through mediation.
I believe so, yes.
Is that something that both parties would be okay with?
I don't have specific instructions on that point, but certainly if the court thought it was a sensible way forward, I'm sure we wouldn't resist.
Ms. Rogers?
I'm so sorry, did you hear me? I was indicating that whilst I don't have specific instructions on the point, if the court's assessment was that sitting down for a mediation would be a sensible way forward, then the defendants wouldn't resist.
I do think that this is a case that would be prime for mediation. I do think that we should, or the parties should have the benefit of going through that process, and we do offer judge-led mediations with the court. And if both sides are happy to undergo the process, then we can arrange for this to, take place during the next, I would say, within the month or so. I know this is probably a difficult time of the year, but I believe that if we manage to, sit down with a member of the bench or even one of our registrars and manage to, go through mediation, then I believe that we can then, it might assist the parties with knowing their way forward in terms of witnesses, in terms of how long the trial is to last for. So I would propose that we have, and this is obviously subject to both of your clients' point of view, we can sit down for the mediation within the month or at any time that, provided it doesn't run on into the timeline set out in the draft case management order. We can sit down for a mediation. Once that's done, if the parties manage to settle, that would be okay. That would be great, actually. If they don't manage to settle, then what we could do is then have another CMC to discuss whatever hasn't been taken care of. If the trial date has, or the trial date has shifted, or the trial length has been reduced, then we can then discuss that in the next case management conference. So I think if we manage to, we would probably we would aim to have the mediation right before you start production.
Sorry if I'm interrupting your thought process or what you were about to say, but may I just ask a quick question? So the claimant is located in London. Is remote mediation something which the court can facilitate?
Yes, actually, it would be remote mediation, yeah.
I can see with the current COVID position, that may be in everyone's interest anyway.
Indeed. Mediation is a voluntary process, so I would want both sides to take their respective clients' view on it. I do think that this is a case prime for mediation, and I think that having that mediation before the actual, I would say, the heavy load on the case or the heavy workload commences would be beneficial in terms of saving costs as well. So before we begin production, I think that would probably be the best. I mean, I'm happy to issue the form of order today. My only concern is, like I said before, the listing date and whether or not we can accommodate a 10 or even an 8-day listing at that point of time.
Entirely understood. May I ask when the court would be looking to list, if it was either an 8-day or a 10-day listing? What period would likely be convenient to the court?
We would have to look. I believe June is possible. I just believe it would be very tight on the court. We honestly, in terms of allowing listings of greater than 5 days, we would have had to have sight of, a witness list, as well as have had sight of most of the pleadings and some form of evidence. If it is the case of 7 witnesses, I'm assuming not all of them will be cross-examined on your side, Ms. Rogers, and whether or not the exchange of witness evidence can be done on the papers. This is something that we would consider. I believe having not have had sight of the claimant's witness list is sort of hindering us from allowing the 10-day listing. I would suggest a 5-day listing to be the maximum at this point, but I understand that that might not be something that the claimant feels is sufficient enough to prove their case. This is mainly why I am proposing mediation to take place before we lock down a trial date. I can block off about 2 weeks in June just in case, and leave that sort of as a tentative date, but whether or not we can find a judge during that period of time is something that we would have to discuss at a later stage. In the meantime, if we manage to lock in mediation proceedings, we can then have a case management conference to discuss anything that is or any items that are still pending on the list of it. I believe the list of issues is now actually settled, but any changes that have been made, if anything has been agreed during the course of the mediation, if the parties no longer wish to call specific witnesses, then that would, I think, significantly, I mean, even if the parties don't manage to settle, then I believe it would significantly reduce the amount of time needed for trial.
Understood. I wonder whether one possibility to consider would be this, that the court were to effectively pencil in, subject to all of the caveats you've just indicated, a hearing in the second half of June, and for us to try to agree in the court to consider and approve an order to that effect today, but on the basis that immediately after the case management conference, the parties, having discussed with the underlying clients, confirm availability for a mediation in December, as you were indicating, with a view to directions being revisited and rediscussed between the parties in light of that mediation if it takes place.
That is a potential way forward.
Yes, that does appear to be a neat way through, taking into account various considerations, certainly from my perspective.
Can we, so I'm looking at the updated version of the case management order.
Yes.
I would prefer if we could have a clean version of this order, as well as I would prefer if we include the period of time for mediation in this order. So I would say once we have received your respective clients' decision on whether or not to undergo mediation, we can then include wording to that effect in the case management order, and then issue the order as is with the dates that you've put in. And I would also suggest that we include in that wording regarding mediation the possibility of conducting another case management conference or a directions hearing to revisit the directions set out in this order.
That can certainly be done, and I'm sure Mr. Wynne and I, between us, can agree an updated draft in light of this hearing. Perhaps it would be sensible if we build in a paragraph to address mediation, pending confirmation from both parties that they wish to mediate, a paragraph to provide for a further directions hearing after any mediation, and then looking down at the trial date, I wonder whether we say at this stage a trial window, or rather a trial listing beginning on perhaps, if convenient to the court, the 14th of June 2021, but subject to the court revisiting availability as you indicated earlier in this hearing.
May I just add one observation, which is just about if the June hearing is penciled in, as it were, would it be possible to have it starting on either Monday the 21st of June or Sunday the 20th? It's just that I have a hearing in the week before the 14th.
Ms. Rogers, are those dates?
That's convenient. Sunday the 20th would be absolutely fine.
Sunday the 20th. Let me just have a look at our calendar. And this is for a 10-day listing. So commencing the 20th of June and ending on the 1st of July.
Exactly so.
If you'll allow me a few minutes just for us to check the calendar.
Of course, thank you.
Okay, so the registry will block off those dates on a tentative basis. I think we can actually confirm the first week of the so that the week of the 20th of June can be confirmed. The second week it looks to be very much available, so we'll block it off tentatively. So the dates are taken care of. We can agree those dates right now. We can include that in the form of the order as well. So we can say commencing it on the 20th of June for an estimated duration of 10 days. And then subject to the changes that we've discussed being made to the order, then we can have this issued within after the weekend.
I understand there was only one other issue on the form of order subject to anything further that Mr. Wynne had, which was as to the issue on which there would be expert evidence. And if the court has the draft, it's paragraph 17 of the draft order. And you'll see there's a provision that, if considered necessary, there'll be permission for written evidence of an expert psychiatrist in relation to two issues. Now, the first of those issues is agreed between the parties. The defendants have some concerns as to the wording of the second of those issues and whether it trespasses on the role of the court, which will, of course, be determining questions of causation. Now, I rather suspect that given the way forward we've been discussing this morning, this may be something that could be ironed out between Mr. Wynne and myself or addressed at a following directions hearing after a mediation, if need be. But subject to that, I wonder, subject to Mr. Wynne's views, whether we might simply add in front of 17 spot 2, insofar as a matter within the expertise of the expert, the extent to which the psychological injury sustained was caused by the defendants.
Yes, that seems to be a necessary qualification, and therefore it's appropriate to include it.
I'm grateful.
So those are namely the three changes to be made to this form of draft. The changes are the provision for mediation proceedings subject to your client's decision. The second change being made to paragraph 17 spot 2. And the third change would be to the trial dates in paragraph 30.
That's correct. I'm very grateful.
Okay.
Thank you.
And just so we have an understanding of when this can be issued, when can the court expect to receive your client's decision as to whether or not they wish to undergo mediation?
My instructing solicitor is presently either on or about to get on an aeroplane, so I'm afraid it probably won't be in the course of today, but we could certainly undertake to respond to the court. Where are we? Thursday. By close of business on Sunday?
Close of business on Sunday. Mr. Wynne?
Yes, we can respond within that time period too.
That seems to be in order. So we will wait for your your client's decision to be sent to us on the Sunday. Along with that decision, if you could, depending on how your clients intend to proceed, if you could include the form of the draft that we've discussed today.
Of course.
All right, thank you very much, Ms. Rogers. Mr. Nguyen, is that would that work for your client?
Yes, it will. Thank you very much.
Thank you very much, Mr. Nguyen and Ms. Rogers. Unless there's anything I can assist you with.
No, not from me. Thank you very much.
Nor for me. We're grateful to the court for the time. Thank you.
Thank you very much.